And this guy don't know how to mute his microphone.
When they come up for you, let me know if you need it turned up, okay? I'm gonna leave it down now.
Mr. Groen, what case are you here on?
I am here on that absolute resolutions, Christine Gilbert, and appears she's online too. So if we can get a breakout, it'd be much appreciated.
All right. So you're here with and for Ms. Gilbert?
I'm here in terms of the plaintiff. I'm on.
Oh, you're here for me. Okay, so you're here for Gray. And Ms.
Exactly.
Gilbert, would you be amenable to speaking with Mr. Groen in a breakout room?
No, that's fine.
All right, I'm going to have Ms. Gilbert and Mr. Groen placed in a breakout room.
Thank you.
Thank you. And then Mr. Renner, you're here on which case? From Venner Law? From Venner Law?
Yes, absolutely. City of Lansing v. Stephen McCory, 2102031 GCF.
All right. And Mr. McCrory is here in person. Yes. All right. Have you had the opportunity to speak with Mr. McCrory?
Not directly, Your Honor.
All right. That's a motion.
All
We
right,
can
sir.
go ahead and put that on the record. And then if we need to get into a breakout room, we'll go ahead and do that. All right, sir?
Fantastic.
Right. So we're on the record in docket 21-0231 GC, the City of Lansing versus Stephen McCory. Will the parties please introduce themselves for the record?
Thank you, Your Honor.
Go ahead.
And thank you, Your Honor. Yep, and thank you, Your Honor. This is Scott Renner on behalf of plaintiff.
All right. It's Leonard, is it? Scott Leonard?
Renner, R-E-N-N-E-R.
And sir, you are Stephen McCory, is that correct?
Yes, sir.
Okay. This is the time set, if I remember correctly. This was a request for an order regarding installment payments. I think this is done at your request, Mr. McCory, for $50 a month. Is that correct?
I had put in for a modify of judgment as well as installment payments. It was in my appeal that I had wrote.
All right. I have an order regarding installment payments indicating the defendant must pay $50 a month. Is that your request or is that Mr. Renner's request?
I did request that I pay $50 a month, but I did ask for a modified judgment as well.
Motion now paid for installment payments to amend order. All right.
And Your Honor, we did not object to the motion for installment payments, and the court has since entered that order. It looks like about a week ago.
Right. It looks like on April 14th, I signed an order that there was no objection to $50 every month, starting May 30th. Is that correct, Mr. Renner?
Yes, Your Honor.
All right. So there, without objection to that, Mr. McCory, did you? What else did you have today?
I wanted the amount that I owed to be lowered.
All right.
Yeah, that was.
So you wanted the order that has already been signed to be lowered.
Your Honor, I think he wants the judgment amount to be lowered.
All right. And and what is your reason for requesting? So what is the debt at now? I've got it at a total judgment. This is a long time ago. This is September 14th, 2021. So Mr. Renner, what do you have the debt at now?
As of today's date, Your Honor, $1,200.82.
$1,200.82. And Ms. McCrory, what is your reason for wanting it to be lowered?
I never received any, well, I'll skip all of that. The reason I want it to be lowered is because I simply can't afford to pay all of that right now. With everything that is happening in my life as far as transitions and bills and stuff, it's just, it in school fines and everything. I'm a full-time student, full-time worker, full-time parent, and it's just really challenging balancing all that and then having that over my head as well. So
this stems from, if I remember, if I see this correctly, this stems from a default judgment. Is that correct, Mr. Renner?
Yes, Your Honor.
And then the request is that the 1,053, the remaining debt of 1,053 be lowered. The reason why is it's just too hard to pay.
yeah.
Mr. Renner?
Your Honor, we believe that the motion for installment payment and the order subsequently entered as it relates to the ability to pay, of course, would satisfy this requirement. However, from a more direct legality standpoint, of course, that would not be a legal defense to or substantiation for that type of request as it relates directly to the judgment amount.
All right. I don't see that as a legal defense, the inability to pay. I do think the ability to pay has been amended so that it's $50 a month, which it doesn't seem like there's an objection. I certainly am able to sign the order, but I'm not willing to reduce the debt at this time. All right. So you should be fine as long as you're paying $50 a month. Is that correct, Mr. Renner? That's the order that the court signed. There's no objection to it. And then
Correct.
Keep those payments up at $50 a month, which reduces the amount that was previously requested and should start you on that payment of the judgment. Okay. All right. So I'm going to indicate that there was no objection to the motion. And the motion was previously signed for installment payments in April of this year. So April of 2023. And all parties appeared. And we'll continue with those installment payments.
Will my, because there was a ask for garnishment of my checks, will those no longer be garnished then?
As long as you're making the payments, there will be no garnishment. Is that correct, Mr. Renner?
Correct. It'd be best practice for the defendant to ensure that his employer does receive a copy of that order.
Yeah. So if you need a copy of this order, which I signed, we'll give you a copy of it so you can provide them, because you're not having any wages garnished as long as you're making those installment payments. Okay. All right. Anything else for the record in docket 21-02031, Mr. Renner?
No, Your Honor. Thank you.
All right, Mr. McCrory, if you hang tight here, we'll get you a copy of this order so you can provide it to your employer. Okay. All right. Thank you. And that's all for the record in that file.
Thank you, Your Honor.
It would be the order that I signed, so it'd be that order. All right.
This was on Driggs and Smith, so I guess we'll let them know.
All right, so is that mine or is that Buchanan's? Okay, so we can live on Smith. They wanted to talk to him, right? But so let's leave that on. Smith and Driggs. My fault. Mr. Driggs, you are Travis Driggs, is that correct?
Yes, sir.
All right. It's my understanding that your attorney has contacted us and indicated that your preliminary examination is to be left on for next week in front of Judge Buchanan. So you're free to leave the Zoom courtroom. All right. So you're free to leave the Zoom courtroom. The PCC indicates that the preliminary examination is to be left on.
Okay, thank you.
Thank you. You're all set.
Yep.
Smith. And then Mr. Smith, also in your case. Are you there, Mr. Smith?
Yeah, I'm here. Hello.
All right, Mr. Smith, you also, your case has also been left on for preliminary examination in front of Judge Buchanan. And so you should be back here. Your prelim is left on in front of Judge Buchanan for April 28th at 8:30. I would indicate, Mr. Smith, you are joining us by Zoom, that you should contact pretrial services, because pretrial services has not been able to get in contact with you. And so I'm giving you notification that you need to contact them in order to set up any type of implementation or process with pretrial services prior to that April 28th date. Do you understand that?
Okay, so I should pretrial services. Who should I call?
Yeah, you should contact pretrial services. Yeah, within 48 hours. What we're trying to avoid is pretrial services requesting a bench warrant for you because you have not contacted them in any way. So I would clear that up if I were you.
So I call the courthouse.
Call pretrial services. Call the 54A District Court Pretrial Services.
Okay.
All right.
Yep.
All right. And then your preliminary examination is left on for April 28th at 8:30. All right, sir?
Okay. Over Zoom?
No, that'll be a live preliminary examination. So you should appear in front of Judge Buchanan in her courtroom. Which courtroom is that? So courtroom 2.
Okay.
All right. So that is live, and I'll indicate for the record that I told you that was live. So you should be here in person, all right?
Yeah, yep, correct.
All right. So that's all for the record in that file. Mr. Smith, you're free to leave the Zoom courtroom.
Thanks.
Can't do that. How come I only have one? Oh, you have short? All right, let's leave those. Goes up there. And then. It's true. All right. So we're back on the record in 22-02369. And Mr. Drone, did you have the opportunity to speak with Ms. Gilbert in a breakout room?
We did, Your Honor, and we have come to a resolution that will be memorialized in a consent judgment. If the court is willing to maybe just adjourn this pretrial out approximately 30 days or so, I'm hoping we're going to be mailing out that consent judgment to Ms. Gilbert today. And I'm hoping within that 30-day time period, we should have that to the court and bypass any need for further hearings.
All right. And Ms. Gilbert, is that your understanding?
Yes.
All right. I'm going to adjourn this matter based on the representations of counsel and Ms. Gilbert. We'll adjourn for 30 days and await the the consent judgment.
Will we be getting that date today, Your Honor, or just look for a notice?
I'll give you that date today, so you'll have
Perfect.
it, and then we can go from there.
Okay.
So we'll adjourn to May 22nd at 8:30. And then once you're able to review the consent judgment and forward it to the court, and then you can tell us if we still need the hearing after it needs to be signed or not. Okay, Mr. Grove?
Sounds good, Your Honor. I appreciate it.
All right, thank you. Anything, Ms. Gilbert, or anything regarding the adjournment and the review of the consent judgment?
No.
All right, we're all set. Thank you for your appearance. That's all on 22-02369.
Thank you, Your Honor.
Thank you. Is that ours or is that? Floyd is one of them, is the one I was asking. So I'll call that. Mr. Yang, are you ready?
He's on Zoom.
Yes,
Oh,
ma'am.
oh,
Yes,
yes, he
sir.
is. All right.
Yes, Your Honor, we're
So-
ready.
Oh,
All
yeah.
right. And you're with Mr. Floyd Jarrett, is that correct?
Gerard Flores, yes, Your Honor. It'll be
All right.
a waiver of 21 days.
All right. Let me make sure I get a prosecutor. I don't have a prosecutor
Okay,
yet. So you'll be up as soon as I get an APA.
sounds good. Thank you.
I hate that. You're here on Southbrook. Mr. Gann, you're here on Southbrook and KMG Prestige.
That's correct, Your Honor.
All right. All right, and is Mr. Foy here, Brian Foy? All right, stand by, Mr. Gann. I'm going to call another case and then we'll go back to yours, all right?
Understood. Thank you.
Thank you.
That one.
That one. All right, so we're on the record in docket, and this is a Judge Buchanan case. So we're on the record docket 23-01125. That is People of the State of Michigan versus Antonio Short. Will the parties please introduce themselves for the record?
Jeff Braddock on behalf of the people, Your Honor.
Antonio Short.
Oh, we're doing Mr. Floyd. I'm sorry. We're doing Mr. Floyd.
I said that one. That's the one I
Yeah,
meant.
yeah.
The reason for that one.
Well, I'm gonna call the right one this time, okay? So,
We'll put it now.
okay, so we're on the record docket 23-01183, People of the State of Michigan versus Jared Floyd. Mr. Yang completely confused on that last call. Will the parties please introduce themselves for the record?
Jeff Braddock on behalf of the people, Your Honor.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Floyd. We are both present via Zoom and consent to having our portion of the hearing via Zoom.
All right, thank you. Sir, you are Jared Floyd?
Yes, sir. Yes, Your
All
Honor.
right, this is the time set for a probable cause conference on a Judge Buchanan case. It's my understanding that Mr. Yang, that the defendant, Mr. Floyd, is going to waive his right to a preliminary examination within 21 days and seek an adjournment today. Is that correct?
That's correct, Your Honor. There is some voluminous video and audio discovery that I need additional time to get through. Therefore, the request will be to waive the 21 days. I've explained that to Mr. Floyd. He understands that and is prepared to do so.
All right. And Mr. Brodowitz, I know this isn't your case, but do you have any objection to the waiver of the 21-day and an adjournment today?
No objection.
All right. Mr. Yang, may I inquire of your client of his waiver of his 21-day rule?
Yes, Your Honor.
All right. Mr. Floyd, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir?
Yes, Your Honor.
And the preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that, sir?
Yes, Your Honor.
You are represented by Attorney Joseph Yang today, and he would be present to contest any charges and cross-examine any witnesses that are brought against you by the people of the state of Michigan in regards to this file. Do you understand that?
Yes, Your Honor.
Okay, it's my understanding that you wish to waive your right to a preliminary examination only within that 21-day period. You would not be waiving your right to a preliminary examination in general. You'd be only waiving your right to that prelim within 21 days, and that's because of discovery issues. So Mr. Yang can present and advocate a zealous defense. You understand that, Mr. Floyd?
Yes, Your Honor.
Is it your intent today to waive your right to a preliminary examination within that 21-day period?
Yes.
All right, Mr. Brodowitz, you also waive the people's right to a prelim within 21 days?
Yes, Your Honor.
Okay, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we'll reset. Can we reset this for Judge?
I can.
All right.
Maybe.
So let's get a date on Judge Buchanan's calendar.
May 12th at 8:30.
So set for May 12th at 8:30, and that will be live.
That works for me, Your Honor. Thank you.
Examination. All right, so, and Mr. Floyd, you have that date, May 12th at 8:30?
May 12th, 8:30. Got it down, sir.
All right. So live in Judge Buchanan's courtroom, that's courtroom 2. Anything else for the record, docket 23-01183, Mr. Roberts?
Nothing from the people.
Anything else, Mr. Yang?
Nothing from the defense, Your Honor. Thank you.
All right, thank you. You're all set. And Mr. Floyd, you're free to leave the Zoom courtroom.
Thank you.
Mr. Short, are you represented by counsel today?
No, sir.
Mr. Brodowitz, did you need to talk to Mr. Short, or should we just leave that on?
I think that can just be left down freely. I don't know what. Case that I gave you.
And Kelly said he needs to take me downstairs to do that.
All right,
I don't
so
know.
get them up here too.
I'm on my-
All right, we'll hold off on that.
That's not what the offer was gonna be on there, please.
Hang tight on that one, okay?
No problem.
Michael, is yours going to be a hearing today, or is it going to be?
I have no idea. All right, is he here?
Yes, he's right here you want to talk to him?
Sure, I guess.
If you'd like to. All right, so you're Mr. Hensley, correct?
Yes, sir.
See, talk to the lawyer here and then we'll put it on the
Thank
record.
you, sir.
Okay. Call him. So we're on the record in docket 23-00762. That's Brian Foy versus Southbrook Villa and KMG Prestige. This is the time set for a pretrial in the matter. Will the parties please introduce themselves for the record?
May I please the town court, Steve Gann, P 7829, appearing for the defendants, Southbrook Villa and KMG Prestige.
All right, and I have looked at the Zoom courtroom. I do not see a representative. Is there a representative of Mr. Brian Foy in the Zoom courtroom? I certainly don't see Brian Foy in the Zoom courtroom. Is there a representative in the physical courtroom of Brian Foy? Let's call him in the hallway just in case. I'm going to have my court officer call in the hallway to see if Mr. Foy's in the hallway. Mr. Foy is the moving party. Is that correct, Mr. Gann?
That's correct, Your Honor. He's the plaintiff on a small claims case, got moved up to district court. So if he's not there, I would move to dismiss.
All right. So this is the time set. The time set for this was 8:30. It is now 9:07. It would appear that the plaintiff has failed to appear for this pretrial. I have no indication of the plaintiffs here, and so I'm going to grant the motion to dismiss.
Thank you so much, Your Honor.
From opposing counsel. All right. Anything else for the record, docket 23-00762, Mr. Gann?
No, sir. Just have a great day.
Okay, you too. Thank you.
To both you and your
That's all
staff.
for the record. 23-00762.
Thank you.
Carrie McCall.
And our document, we don't have an appearance.
All right.
It's already said he sent one during her arraignment.
We
So
just haven't got it
Oh,
I
yet.
asked him to send in another one.
Because he sent in a limited appearance for the arraignment. Is what I was told. Not the same.
We can put it on the record. 23. That's the second. That's the last one. Right? Mr. Brodowitz, are you ready on Miss McCall?
Yes, Your Honor.
All right. All right, so we're on the record in docket 23-01041. That's People of the State of Michigan versus Carrie McCall. Will the parties please introduce themselves for the record?
Good morning, Your Honor. William Amadeo, P76194, on behalf of Ms. McCall. Both appear via Zoom, waiving the right to be present in person. Carrie, please state your name so Judge Flores knows you're here.
Carrie McCall.
All right. And you can hear me all right, Ms. McCall?
Yes, sir.
All right, thank you. And then Mr. Amadeo, my understanding is you had a limited appearance. Our record doesn't reflect an appearance at this time, but we understand that there's one coming. Is that correct?
That's correct, Your Honor.
All right. Mr. Brodowitz, this is the time set for a probable cause conference. How are we proceeding?
Yes, Your Honor. At this time, the people have extended an offer to the defense of sobriety court in this matter. And I received an email from about a week ago from Ms. Otten that they had, I guess, done sort of pre-screening of Ms. McCall, and it looks like she's eligible, but I believe they still need to do the actual screening process. So I think at this point, we would just be leaving it on for preliminary exams, which need to be evaluated through sobriety court.
Okay, is that your understanding, Mr. Amadeo, that the case should be left on for preliminary examination in order for Ms. McCall to be evaluated or continued evaluation for sobriety court?
That's correct, Your Honor. And I guess I would ask to adjourn the prelim for 30 days so she can get her screening done, but it is an accurate statement.
I have no objection to an adjournment.
All right.
30 days in order to get the screening.
This, Mr. Amadeo, is Ms. McCall willing to waive her 21-day rule right in order for that 30-day adjournment?
Yes, Your Honor.
May I inquire of your client of their 21-day waiver rule?
Of course, Judge.
All right. So, Ms. McCall, you understand you have the right to a preliminary examination within 21 days of your date of arraignment. Do you understand that?
Yes, Your Honor.
All right. And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You understand that, ma'am?
Yes, Your Honor.
And you'd be represented by Mr. Amadeo, and he would be present to cross-examine any witnesses and contest any charges brought by the people in regards to this file. Do you understand that?
Yes, Your Honor.
Okay, it's my understanding that if you waive your right to a preliminary examination, you will not be waiving your right to a preliminary examination in general. You'll be only waiving your right to a preliminary examination within that 21-day period. And we're doing that so that you can get evaluated for sobriety court. Is that your understanding, ma'am?
Correct. Yes, Your Honor.
Okay, so is it your wish today to waive your right to a preliminary examination within the 21-day period?
Yes, Your Honor.
All right. Mr. Brodowitz, people also waive their right to a prelim within 21 days?
Yes, we do, Your Honor.
All right, I find the waiver of 21 day to be knowing, voluntarily, and accurately made. And we will set this out for the screening. So 30 days.
May 25th.
So we'll set it for May 25th at 8:30. So you have that date, Mr. Brodowitz?
Sorry, what again, Your Honor?
May 25th at 8:30. All right. You have that date, Mr. Amadeo?
I do, Your Honor. Will that be via Zoom?
On 8:30 on that preliminary examination, if we'll leave it as a live hearing until I hear differently from the parties, okay? That means that she gets through the screening, but if it's just, if the purpose of it is just to make sure that she's available and that we're moving to sobriety court, I don't have a problem with that on Zoom.
Okay, thank you, Your Honor.
All right. Anything else, Mr. Brodowitz? Do you have any objection to this being Zoom if this is a referral to sobriety court?
It's simply a referral to sobriety court. Objection.
All right. Let's leave it for live right now because there may be some paperwork that she has to fill out in order to get over to Judge Buchanan's sobriety court. So let's leave that for live just in case, okay?
Understood, Your Honor.
All right. Anything else for the record? Docket 23-01041, Mr. Brodowitz.
Nothing from the people. Your
Anything else, Mr. Amadeo?
No, thank you, Judge.
All right. You're all set. We'll see you on that date, Ms. McCall, on May 25th at 8:30. Please keep in contact with your attorney, Mr. Amadeo, if you have any questions. All right, ma'am?
Thank you. Yes, sir.
All right.
Thank you,
Thank you. You're all
Judge.
set.
Take care. Bye.
Okay. All right. Mr. Vanloni, you ready to call your case?
I am.
All right. So we're on the record in docket 22-04264. That is Tamara Farrell versus Waylon Hensley. Will the parties please introduce themselves for the record?
Name's Waylon Hensley.
All right. And
Good morning, Mike Mataloni on behalf of Ms. Farrell.
all right. This is the time set for a hearing concerning the land contract forfeiture, if I remember correctly, and I took a look at the file. Mr. Mataloni, how are we proceeding today?
Speaking to Mr. Hensley, he indicated that he would like 35 days from today to vacate the premises. I consulted with my client. She's fine with that. And I indicated to him that we would be entering a money judgment, also asking the court for a money judgment for $5,083.
All right, and you're going to follow that up with an order, Mr. Mataloni?
Yes.
Okay. And my understanding on a land contract, you've got some redemption period on land contract, but you're willing, as long as you have that 35 days, you're willing to use that time period in order to vacate the property.
Yes, sir.
Okay.
I have a house that will be ready by May 15th. So
All right, so that should suffice. Is that your
You guys mail the your copy of the order to still 524 Lee?
Yes, I'll have everything will be forwarded.
Okay.
All right. All right. Anything else for the record, Mr. Manaloni, on docket 2204-264?
No, sir.
All right.
I know you wanted a hearing. You don't have anything going on, so.
Yeah, well, Mr. Hensley, thank you for your appearance today, okay?
Thank you, sir.
All right, we'll see you. Thanks, Mr.
Have a good
Manaloni.
Yeah.
Thank you, James. All right, thank you, David.
Sorry, they needed to file.
All
Sorry.
right. No,
I couldn't figure out how to like gracefully do that in the middle of everything else.
I'm glad you showed up today.
I don't think. No worries.
So we're on the record in docket 2203-028. That is People of the State of Michigan versus Travis Henderson. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney Derek Espinosa, the public defender on behalf of Mr. Henderson. Mr. Henderson is appearing by Zoom video.
All right, sir, you are Travis Henderson?
Yes, sir.
All right, and you can hear me all right, Mr. Henderson?
Yes, I can.
All right, this is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated, today's date and time set for probable cause conference. The people have made an offer where we would be adding a count 5 of DV second and a count 6 of attempted interference with electronic communications. And there was also a discussion with Mr. Etheridge for an agreement to a kilobrew of no upfront jail. And with a successful plea to that, the people would be dismissing counts 1 through 4. I had conversations with Mr. Etheridge. I believe this is going to be left on for preliminary exam so that the defendant has time to consider the offer.
So the offer's been made and this is left on for preliminary examination at this time. Is that a correct statement, Mr. Etheridge?
Yes, it is, Your Honor. That's a correct recitation of the plea offer that I've discussed with Mr. Henderson. Mr. Henderson, I did ask for the no upfront jail and the prosecutor has agreed to that. That's something additional that we didn't talk about during that video meeting.
Okay.
All right. So Mr. Henderson, my understanding is we're leaving this preliminary examination on for April 28th at 2023 at 8:30. And the offer has been made and extended to give you some time or to give some time to think about it. So is that your understanding, Mr. Henderson?
Yes, sir.
All right. Anything else for the record? Docket 2203-028, Mr. Brodowitz.
Nothing from the people.
Anything, Mr. Etheridge?
No, Your Honor, thank you.
All right. We'll see you back here on April 28th at 8:30. All right, sir?
Thank you.
Okay, thank you. You're all set, Mr. Henderson.
Thank you, Your Honor.
Thank you, Mr. Etheridge. So Mr. Gaskin.
Mr. Gaskin.
Okay. There's not an offer, there's a bazillion pieces, right?
All right.
No, Gaskin was, the offer is going to be assault restitution. For the,
A and B restitution.
yeah, restitution for the door.
Okay.
That was what our offer is going to be on that. Savage.
I just don't leave it set because I don't have
See that
anything,
on?
obviously. I don't have any
We'll see.
separate or anything. But I'll note that for the file.
Yeah, and then Wyndham was. That was tied into.
Yeah, he's
Okay.
taking that. Mhm.
All right, so let's do Gaskin first because he's in custody. So we're on the record in docket 23-01124. People of the State of Michigan versus Duval Gaskin. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Gaskin.
And sir, you are Duval Gaskin,
Yes, sir.
and you can hear me all right, Mr. Gaskin?
Yes.
All right, this is the time set for a preliminary examination. Mr. Brodowitz, I'm sorry, this is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated today's date, time set for probable cause conference. Based on my discussions with the defense, it looks like there were some issues with Mr. Gaskin and his counsel. So I believe at this time, we're simply going to leave this on for a preliminary exam. I have made a brief offer, but I don't think Ms. Robinson's had time to discuss that with Mr. Gaskin at this time. So.
All right. And for the record, so I don't have Ms. Robinson as the counsel of record. However, it's my understanding that Mr. Gaskin has made application or is in the process of making application, or maybe it's been complete. But Ms. Robinson, any comment on that?
Yes, Your Honor. So it looks like he did originally apply with the office and was denied, but then, or said that he wasn't denied, excuse me. He said that he was going to hire his own attorney. That did not work out for him. So he did reapply. And it looks like he will be approved. It just hasn't happened yet. So I am sped that up with my supervisor.
All right. So Mr. Gaskin, it appears that your application is going to be successful to the Public Defender's Office. We're going to leave your case on for April 28th, 2023 at 8:30. And there has been an offer made. You can discuss that with your public defender. Okay, Mr. Gaskin?
Yes.
All right. Anything else for the record? Docket 23-01124, Mr. Brodowitz.
Nothing from the people.
Ms. Robinson?
No, Your Honor.
All right. You're all set. We'll see you back here on April 28th, sir.
All right, thank you.
Thank you. Now, Mr. Savage is joining us. So we're on the record in docket 23-00947. That is People of the State of Michigan versus Christopher Savage. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Savage.
And sir, you are Christopher Savage?
Yes, sir.
All right. And you can hear me all right, Mr. Savage?
Yes.
All right. This is the time set for preliminary exam for a probable cause conference. Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor. At this time, I believe this matter will also be left on for preliminary examination. The people have made an offer for Mr. Savage to plead to an added count 2 of setting a spring gun, at which time on plea we would dismiss, which is a 1-year misdemeanor, at which time we would dismiss count 1 of carrying a concealed weapon. But however, as I stated, after conversation with the defense, I believe this is going to be left on for preliminary exam as well.
All right, Ms. Robinson, is that your understanding?
Yes, Your Honor, he's considering the offer. I'm covering for Mr. Abbott today, and so I'm not up to speed on the facts of this case. And I wanted to give him a chance to talk with Mr. Abbott about that. So we're just gonna leave it on for prelim for him to consider the offer.
All right, thank you. Mr. Savage, you understand an offer's been made and we're leaving this on for preliminary examination on April 28th at 8:30. Do you understand that, sir?
Yes, sir.
And that'll be a live, so you should be in person live on the 6th floor for your preliminary examination date in my courtroom. All right, sir?
All right, thank you.
Okay. Anything else for the record? Docket 23-00947, Mr. Brodowitz.
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Savage, if you have any questions, please keep in contact with your attorney. It's Mr. Abbott, correct?
It is.
Yeah. Keep in contact with Mr. Abbott. We'll see you here on April 28th. All right, sir?
All right, thank you.
All right, you're all set. Thank you for your appearance today.
Yep.
It's great if during people's day off. We don't get dates off.
What is it? This one? Deshaun. I'm confused enough without having extra files.
Actually. I just forgot to pull it out. I'm sorry.
No problem. All right, we're on the record in docket 22-03408. That's people of the state of Michigan versus Tyrese Wyndham. Mr. Wyndham, you can come up here. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Wyndham.
All right, and sir, you are Tyrese Wyndham? All right, I have an order for fingerprints. Has Mr. Wyndham been able to get his fingerprints taken? Right. So when you leave here today, when we're done with the probable conference, I'll give the order and you should go get your fingerprints taken. My court officer will tell you where to go, okay?
I know when I had bought it out, they got.
The computer doesn't have you as having any fingerprints, so at least check to make sure, all right? And I do have an order in the file, all right? All right, this is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor, at this time, the people have made an offer for Mr. Wyndham to plead to an added count 2 of embezzlement 200 to 1,000 with full restitution and an agreement for HYTA if eligible. I believe Mr. Wyndham has decided to accept that offer.
All right, is that a correct statement, Ms. Robinson?
It is, Your Honor.
All right, so I'm gonna have you restate that record offer. So the offer is to, and is this from a warrant or let's see, it is from a warrant. So we'd add a count 2. Count 2, and that count 2 is again?
Embezzlement 200 to 1,000.
Okay, embezzlement 200 to 1,000. What's the PAC code for that?
That would be 750.1743A.
Okay. And that is a 93-day or a 1-year misdemeanor?
That's a 1-year misdemeanor.
1-year misdemeanor. And or $500?
And or $2,000 or 3 times the amount embezzled, whichever is greater.
For $2,000 or 3 times the amount. All right, so Ms. Robinson, I'll restate that for the record. It's the agreement is to add account 2 of embezzlement 200 to $1,000 under PAC code 750.1643A. That's a 1-year misdemeanor and or $2,000 or 3 times the amount embezzled. Is that correct?
That is correct, and there's no objection to HIDA if eligible.
Okay, so no objection to HIDA. Is that my understanding?
Yes, Your Honor. People have no objection to HIDA if eligible.
And is there any restitution in the matter?
Yes, there is, Your Honor. From the numbers I have from the police report and an asset protection report from Lowe's where this incident took place, the restitution amount would be $11,607.67.
All right. And I'll wait for, of course, we're going to send this probation that I'll reaffirm it. But is that your understanding, Ms. Robinson?
It is, but yes, I would like to just send it to probation
Yeah,
to make sure.
just to make sure that to confirm the amount. All right. May I inquire of your client of his understanding of the negotiations and his advice of rights on the misdemeanor, please?
You may.
All right, Mr. Wyndham, you understand that you've heard everything that's been said here today. We're going to add account 2 of embezzlement 200 to 1,000 pursuant to 750.1643A. The ultimate penalty for that offense is a 1-year misdemeanor and or $2,000 or 3 times the amount of the embezzlement of the restitution alleged. Do you understand those are the nature of the most potential you could receive under these facts? Do you understand that? All right. There's no objection to HIDA. As I understand it, we'll be referring this to probation, okay? So that they can do a pre-sentence. A restitution right now is at $11,607.67. Of course, that'll also be reviewed by your probation for your pre-sentence report. Do you understand that, sir? All right. Is it your wish today to plead to count 2? All right. I'll walk you. You have certain rights in this misdemeanor case, and I'm going to walk you through those rights. All right, sir? You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question any witnesses brought against you to appear at trial. You, of course, are represented by Public Defender Aaron Robinson. Do She would be here at trial to cross-examine any witnesses or contest any charges brought against you. Do you understand that, sir? Okay. You have the right to have the court order any witnesses to appear in your defense. You have the right to remain silent during the trial. You have the right to not have that silence used against you, and you have the right to testify at trial if you choose to testify. If your plea is accepted, you will give up the claim that the plea was a result of any promises other than what we've discussed, okay? Or threats that it was not your choice to plead guilty. You'll also be giving up your right to appeal any issues at trial because you won't be having a trial. You'll be pleading guilty to this case. Is it my understanding it isn't your intent today to waive your rights and to plead guilty to this? All right. I'm going to have you raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Okay. I'm going to bring your attention back to May 18th, 2022 at the fence location of 6821 South Cedar Street, City of Lansing, Ingham County. Were you there on that date at that time, Mr. Wyndham? Were you at the South Cedar Street address in the City of Lansing on May 18th, 2022? Okay. And were you working at Lowe's at the time? All right. And then what did you do at Lowe's to make you guilty of count 2? Yeah, you're pleading guilty to converting or converting money to your own use that was actually from Lowe's. So why don't you tell me in count 2 what you did?
I was working at the register, just giving some.
So you have to speak up. I can hardly hear you.
I was working at the cash register.
Okay.
Giving people gift cards.
Okay, so you were working at the cash register and you were giving people gift cards. Okay, and the people had no right to the gift cards, I take it? Okay, and that the gift cards belong to Lowe's? So you were taking the gift cards as an employee of Lowe's and converting it and giving it away to people you know?
I didn't know them.
Okay, so you're just giving the cards away to people. Okay. And you knew that was wrong at the time. Okay. Any questions concerning the factual basis, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
I find the factual basis to be knowing, voluntarily, and accurately made. I'm going to set this for pre-sentence report and for probation. So after you leave here today, why don't you just go right to the 5th floor, okay? And we have an order for you, so you should get your fingerprints. But you go right to the 5th floor and answer any questions they have. What they're going to do is they're going to develop a report for me, and we're going to see what options are available for us sentencing, okay? And I'll give you a sentencing date today, okay? So report to the 5th floor today. And you said you're going to indicate you're going to report today. And I'll set sentencing for. So sentencing is set for June 6th at 2:30.
Is that on a Friday?
June 6th would be on looks like a Tuesday, on a Tuesday afternoon. All right. So June 6th on a Tuesday afternoon, go right to probation and then go get your fingerprints. All right. All right. Anything else for the record in docket 2203408, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Wyndham, we're all set. We'll see you on June 6th for your sentencing, okay?
The court date I was supposed to have next Friday.
No, you don't have a preliminary examination next Friday. That's off. You've pled. Now let's get you to probation and get that report done, okay? All right. That's a fast and furious hour, but we're all set.
Yay.
Yay is right. Yay. Thank you, Ms. Robinson.
No problem.